Hello and welcome to the ACEDS webinar channel. My name is Mary Mack. I'm the Executive Director of ACEDS, the Association of Certified E-Discovery Specialists. And today we're going to have a fabulous webinar on a very timely topic, the GDPR, and it is sponsored by Zylab. And ACEDS is very, very grateful to our affiliates and partners that bring us these breaking educational webinars. A couple of things on housekeeping before I introduce the session. You can ask your questions in the Q&A window down at the bottom. The slides will be available after the webinar along with a link to the recording. So you will have those resources. And without further ado, I am going to introduce the webinar. So that it's entitled No Silver Bullet, covers all GDPR requirements, but there is a lot you can do. So there's going to be a practical webinar as well as a substantive one. And to present to you, I have two of my good friends, Ken Rashbaum and Jan Scholtes. And there's more disclaimers than normal here, I think, for me. Those of you who know me know that I used to work for Zylab, and so Zylab is very dear to me. And Ken Rashbaum and I worked together back at FIOS, and when Zylab wanted to become HIPAA compliant, Ken was the first person that I tapped. Ken's also an author in my e-discovery for corporate counsel treatise published by Thomson Reuters West and has been for years. So those are my disclaimers. And to introduce Jan is the Johannes Scholtes. Jan, to his friends, is the Chairman and Chief Strategy Officer at Zylab. He's also a professor and the holder of the Extraordinary Chair in Text Mining in the Artificial Intelligence Group at the University of Maastricht. Jan, with his leadership at Zylab, brought Zylab into the UN War Crimes Tribunals. He was tapped to help during the FBI Enron investigations and in the executive office of the president. So Zylab is a long-time e-discovery and e-disclosure organization. Now, Ken Rashbaum is a partner at Barton. And Ken's, when I think about Ken, I think about privacy. I think about the HIPAA, of course, and then the GDPR, cross-border data flows. He's the guy that you want for both contracts, compliance, breach notifications, those types of things. And Ken has been working in this field, I would say, for over a decade, way before anybody was thinking about what kind of legal issues arise when data is transferred, either protected data or data going across borders. So we are very, very fortunate to have these gentlemen here, and we're going to have a very robust discussion here. So we're going to talk about GDPR, what are the facts, some relevant technology for GDPR to meet those requirements, and then some use cases for our e-discovery community. So without further ado, I'm going to hand the baton over to Ken Rashbaum. And Ken, would you start us out?
Thank you, Mary. Appreciate that, and thank you for that wonderful introduction. We are living in a time of great change, which should not come as a surprise to anybody. And Europe has reacted to that change in the ubiquity of technology for business in a very distinct way that most of the world will probably be following within the next 5 to 10 years. The GDPR, the General Data Protection Regulation, is probably the most sweeping attempt to regulate digital information, and specifically digital information used in e-commerce, certainly in any time that I can remember. And I've been involved in the information governance area almost as long as Mary. So we're going to start by talking about what it is, how we got here, some general themes for you about implementation of the GDPR in a way that will make sense for your organization. This is not a set of regulations where you can just leave it on a shelf and read it, and it will tell you everything you need to know about privacy and security. It's not the gospel. It is law. It has very sharp teeth, but it is essentially a guide that will do nothing less than revolutionize the way we use the Internet. So the GDPR comes into full effect May 25th of this year. That's not very far away. It's already been mostly in effect for the last 2 years, but the penalty phases, which I'll get to in a moment, which really get everybody's attention when you talk about GDPR, start on May 25th. So the GDPR arose from the European Union Privacy Directives of 1995 and 1996. That alone, those numbers, should tell you why something new was needed. The directives were not law. They were a minimum standard by which every country had to implement privacy legislation. They couldn't go below the directive standard, but they could sure be stricter, and most of them were. The GDPR will be law in all 28 member states. And yes, I said 28 deliberately, because after Brexit, the UK Data Protection Act will come into full effect, and that essentially mirrors the GDPR. There will still be some local law variations, and depending on where you're doing most of your business, this will be something that will be critical for you to know. I'm based in New York City. When I get asked about GDPR by American companies react as many of them do when it comes to non-U.S. law. Really? Do we have to? Is this really going to affect us? The answer is yes, yes, and yes, because the GDPR applies to any organization that offers goods or services in the U.S. or in any way tracks the behavior of EU data subjects, not just EU citizens, mind you, EU data subjects. Now, I said I was going to talk about the penalties, and this is really going to be shocking for those of you who haven't heard. The top-level penalty for reckless or intentional breaches can be up to 4% of global revenue, or 20 million euro, whichever is greater. And we're not just talking about criminal conduct. We're not just talking about intentional conduct. If there is a disregard of basic principles in the GDPR, the regulators may well apply that higher level. The second level is half of that, 2% of global revenue. Remember, revenue, not profit. Or 10 million euro, but boy, that's an awful lot of money. Okay, let's go to the next slide. Essentially, if I had to sum up the GDPR in a couple of sentences, it would be this. The data subject has the right to determine what is done with his or her data and to be told what will be done with his or her data, and that data must be protected. That essentially sums up several thousand words for sure. But the key themes here are essentially this. One is transparency. In addition to being told what's being done with the data and giving the data subject control to an extent over what's done with his or her data, the data subject also has digital rights. They have the right to access the data, to see what you've got on them. They can ask to have it corrected, amended, or in some cases, deleted entirely. Those of you in the U.S. who do work in the healthcare space will find some of this sounding familiar, because a lot of this is going to sound like the U.S. healthcare regulation, HIPAA. One of the differences, prime differences between the GDPR and HIPAA is that whereas HIPAA separates the privacy and security rules, the GDPR melds them. There is no hard and fast distinction between privacy and security because the GDPR recognizes that in 2018 you can't have privacy without security. So the data has to be protected, and yes, that includes encryption at rest and encryption in motion. If you're going to share the data, you must share it with trusted third parties. Make clear that you're sharing it, why you're sharing it, and make sure that your agreements with your third parties, and that includes cloud services, have provisions for compliance with the GDPR. The third aspect, and this is relatively new, is something called data minimization. What that means is that there is a rule in the GDPR that you can't keep data for longer than the purpose for which you collected it, and then you have to either get rid of it or remove any identifiers in it. And the technical way to do that is something that Jan is going to be spending a lot of time discussing. The closest corollary we have to that in the U.S. is in the New York Department of Financial Services cybersecurity regulations, which have a similar provision. Also, incident reporting is now made not only mandatory to have an incident reporting, a breach reporting protocol, but it's shorter than anything you've probably ever come across. The period of time to report to your regulator within the EU is 72 hours. 72 hours from discovery of the breach. There's a longer period of time to notify the data subjects. But think about how you're going to be able to do this within 72 hours. There is no U.S. state that has a provision that short. The other one that comes closest is Maine, and that's 7 days. Other than, of course, the New York Department of Financial Services rules. The next principle is accountability. I got my start in data privacy, as Mary alluded to earlier, in healthcare. And I have done multiple teaching rounds at medical schools and in-service lectures for healthcare departments. And this is relevant because U.S. healthcare law derives from European Union privacy law. And the young doctors were told, if you didn't write it down, it didn't happen. Now, that's the case in a lot of industries, too, but it's now law. A core element of compliance in the GDPR is documented policies and procedures, and we call this accountability, and reporting on how your policies and procedures are maintaining your controls over information. The final principle here is international transfers. We saw this under the data privacy directives, where you couldn't send data outside the European Economic Area to a country that had not been determined to have equivalent data protection. There are 7 of those, and the U.S. isn't one of them, without certain safeguards in place, like a data transfer agreement or binding corporate rules or registration with a U.S. program that used to be known as Safe Harbor and now is known as the EU-U.S. Privacy Shield. But you must now have provisions in your processes for sending data pursuant to these data transfer agreements that have protections within them. Let's move to the next slide. There are other aspects of this as well, one of which is that if you are doing data processing by automated means, which is a fancy way of saying analytics. In many cases, you will have to have that in your privacy notice and your consent, particularly if your analytics are using what are called aspects of sensitive or special personal data, gender orientation, religion, political party, ethnicity, even labor union membership in some cases. The GDPR has extraterritorial reach. It does apply to U.S. companies. And if you have any doubt about why and how it applies to U.S. companies, let me try to put some of those doubts at rest. It's the rare business these days that doesn't have global scope. Anybody with a website can market to anywhere in the world. Once you're marketing to the European Union, you're covered by the GDPR. And the last thing you want is an aggressive regulator levying a fine, whether you have anything that can be attached to pay the fine in Europe or not. The reputational damage would be significant. The other thing that we are finding here in my practice is that GDPR is now a door opener. It is a business opportunity. What I mean by that is that a lot of the contracts that my clients are getting to replace older contracts or even now an addenda to existing ones have requirements that the client must meet the standards of the GDPR. Now, I saw this under the old European Union privacy directives, but we're seeing it even more now. And what's the significance of that? That means that if you meet GDPR standards, doors will open for you. You will get business you wouldn't be able to get otherwise, large institutional customers in particular. So when you're socializing this within your organization and you're running into some of these questions like, do we really need to spend the money for this? Is it worth it? What's the return on investment? It's generally not always the best idea to say, well, if you don't do it, you're going to get penalized. That flies over a lot of people's heads. But if you say to them, if we do this, new markets open up. We may be able to get additional business. People will pay attention and budget lines may get freed up. Jan, let me turn it over to you on some of the technical issues with regard to the need for removing identifiers in data, particularly in archives.
Yeah, thank you very much, Ken. Very clear overview. And what I would like to talk a little bit about is something which so far has not been used a lot in the US, which is called pseudonymization of personal data. Because under the GDPR, there are three types of information which are being distinguished. Three types of personal information and three types of efforts you have to take. If an organization needs to use personal information for their business, like for instance, the tax authorities, they need to know your name, your IRS number, your bank account number, and a lot of other information. They cannot do their job without it. Then they are allowed to collect this information, and they're also allowed to store it in an identifiable way, which is on the left side of this little table here that you see. Now, on the far right side, if you have absolutely no reason why you would need such personal information for your business, you cannot justify it, then this type of data needs to be anonymized. Means that it's completely removed, it's blacklined, and there's no way to trace it back to an individual or to a subject in the European Union. And what the European Union did is that they, when they drafted these laws, is they created an intermediate version, which they call pseudonymization. And with pseudonymization, you are allowed to replace the name by a number or pseudonym, for which you keep in a separate table the reference to the original name or the original person. And then you can actually disclose data which is pseudonymized, and if the regulatory agency or somebody, another third party or civil party or the counterparty litigation has identified a certain individual as the person who is either guilty or from whom they need to know all the names, then they can actually ask for the name of this individual and then trace it back to the individual. Now, pseudonymization is something which has already been used in a lot of recent disclosures from European organizations, European companies to U.S. regulatory agencies. Now, the pseudonymization is something which is a very convenient tool. So it also allows individuals and organizations to kind of seek the middle way to providing information and still keeping a link to the original individuals or personal data if that's needed. One of the things that is important to understand from pseudonymization is that you have to be careful, because if there's like only one, for instance, butcher in a small village, and you're talking about the butcher, then everybody knows who it is. So you should not just pseudonymize the names, you should also pseudonymize other information which will allow one to trace information or data back to the original individual, which can be kind of a challenge.
Jan, I have a question for you. You said that if a business doesn't need personal information, then pseudonymization or anonymization may not matter. But as a practical matter, given the definition of protected personal data under the GDPR, it's the rare business that won't be using personal data. Isn't that true?
Well, that depends what you're doing. And if you have a good business reason, then it's very easy to justify that you need this information. But there's also companies who are collecting all kind of information about individuals where the individuals don't know that their information is being collected. The company doesn't need it for their primary source of business. And maybe they want to sell it to other parties, which can be a violation of the GDPR as well, which is actually one of the reasons why in Europe it's almost impossible to buy mailing lists of individuals already at this moment, because people are not allowed to sell these lists without prior consent of the subject. So you must really have a very good reason to collect this type of personal information as of May of this year. And that's going to be a major change, especially for companies that have been collecting all this information, sometimes without a real purpose. And that's something you can no longer continue to do.
Okay,
Does that answer your question?
Yes, thank you.
Okay, so we've been, and I'm sure that you have also been asking yourself, so what's the best workflow when we need to disclose information for whatever reason? We can no longer just disclose information which contains personal information. Do we need to redact it? Do we need to pseudonymize it? Ken and myself, we had a couple of discussions here in the preparation of this webinar where we were asking ourselves, how can we justify this? What is the return of investment? And Ken, you already said, well, the return of investment is that you get more business. And if you don't do this GDPR, well, I can tell you for sure you're absolutely right, because every contract I've seen in the last 6 months has like a 2-pager GDPR clause in it. And if you're not compliant with the GDPR clause, you can forget to do business with any company in Europe. So that's absolutely a good reason to do it. But we were talking about a couple of other things, Ken, and you had some concerns. Maybe you can share them with the audience.
Well, that was one of them, which is that the definition of data protected by the GDPR is not just name, it's not just email address. It includes, Jan, to your point, data that combined with other information can allow the identification of the person. remember where this arose from. The GDPR arose from the outdated nature of the directives and events in the U.S. that showed that information is not being protected very well, and the European Commission got very concerned about that. I'm talking about the revelations of Edward Snowden, the multiplicity of data breaches, and of course all this came into draft before the events of the last several months. Look what's just being revealed now about mining of Facebook information. So, you know, there is most businesses are going to have, for purposes of doing their business, some form of protected information. And so the concern was, how can you apply these principles practically? And while you may not have the capability or technique to pseudonymize or anonymize data when it's being sent to your company, you can only process that information, remember, for a permitted purpose in the GDPR. The GDPR is a regulation of exclusion. You can't do it unless the regulation says you can. So either you have a legitimate purpose for processing it, which is usually consent, or an exception in the statute, or once you have it and you're going to store it somewhere, how can you store it in a way that complies with the GDPR? And that's, I think, where the sweet spot is for a technical tool that will allow these removal of these identifiers so that you can keep historical business data, historical litigation data for periods of time which you otherwise wouldn't be able to do.
Yeah. No, and I absolutely agree with that, because if there's no need to collect or store personal information for one's lines of business, then it's probably the most economic way to remove those archives. Unless you have to keep them for compliance reasons or for other reasons, legal reasons, then you should consider pseudonymizing or redacting them. And in that case, you definitely want to use technology, because technology is many times more cost-effective and affordable than doing everything manually. On top of which, a lot of humans make errors, and they make a lot of errors because this is very boring and not very interesting work. So we see that computers not only outperform humans, but they're also faster and smarter and better. And so that's one way to do it. If there is value in an archive, then you should definitely offset that value against the investment you have to make, and use that when you have to decide whether you want to redact and pseudonymize or anonymize these archives, or just get rid of them. And but just leaving them and doing nothing is not really an option. Okay, you want to add anything to this right now, or shall I move on, Ken?
No, you should move on. I think we're covering what we need to cover. This is great.
Good.
Go ahead.
Okay, so I want to touch technology a little bit here, and then explain it a little bit, and then take us down to a couple of very concrete use cases. We have identified 5 use cases where data disclosures from Europe to the US are affected, and then how to deal with those. So first, what is relevant technology for the proper implementation of GDPR, or for the proper handling of data transfer? Of course, next to what Ken already discussed, the European Union Privacy Shield, which allows parties to store data on different continents. The technology that you need when you're asked to disclose data, it starts with of course, collection and something we call deep processing, which means that if you have a data set, every individual component needs to be made searchable. If it's not searchable, you cannot use automatic tools to analyze it or to redact it, or let alone pseudonymize it. And this means that you have to unpack data in containers, which means unpacking zip files. You have to OCR, optical character recognition, non-searchable data like bitmaps or non-searchable PDFs. You have to deal with embedded emails or emails and calendar items and attachments, and you have to make every individual component of these complex document families searchable. On top of that, you have to think about multimedia, how you're going to deal with audio files, with images, pictures, video files, and this is what you do in the processing phase. I would definitely advise you to look at deduplication technology. Often in these large archives, 80% or more are duplicates, so preventing double work is very cost efficient. You're not going to be able to just do identification of information with search. Plain search will not get you there. You need at least to be able to use incomplete search. I'll show you a couple of examples. You need to be able to use fuzzy search. You need to be able to find, even if you don't know exactly what you're looking for. And the only thing that's going to help you there is advanced text mining, and that will allow you to detect potential redactions. You need to apply the right redaction format, depending on legislation. Redactions can be black, they can be white with a black square around it. They can be anything. You have to define the format. You have to mention a reason for redaction in the redaction. If you're using pseudonymization, you have to put the name of the pseudonym in there. You have to review the redactions. So I'll show you how that can be done. If you don't review them, you have a very large chance that you're disclosing data still without redactions, or you're making errors. So you need to review it, and you need to validate the quality levels of this whole process. And then, like you have to do with a privilege log, you have to report on the redactions. In FOIA, this is called a VON index. And so for every redaction you apply, you have to include it in a list and in a report, and you have to list the exact reason and the exact rule why you apply this redaction. So altogether, I think you understand it's pretty much impossible to do this without the use of technology. Now, if we take a look a little bit at I'm taking you too far here. There we go. So how does this look? At the end of the day, if you have applied the redactions and pseudonymization, this is how it looks. At the bottom, you see a redaction, which is completely anonymized, and you see that the other names and words, the names and words have been replaced by numbers, which can be then traced back to a reference table, which is stored somewhere else. But this is the whole idea of pseudonymization, where you have these individual, and 1027 in this case is John Doe, and 1300 is Jane Doe. And this is how the whole process looks at the end of the day. And here we're just presuming that the redactions can be applied in blue, and there's no additional requirements that have to be taken into consideration. Now, how do you find these type of patterns and words that you need to redact? There's actually 5 different types of information, and they have different levels of complexity. Very easy to detect are very specific patterns that have no ambiguity, like email addresses, URLs, FTPs, and those type of things. They're very easy. You can only write them in one way. There's no spelling variation, so there's no variations with spaces or dots or commas. And it's very easy to find those by using a variety of different search techniques. There's also specific patterns, but they have different spelling variations, like phone numbers or social security numbers, or in your IBAN bank numbers. So you can write them with spaces, with dots, with hyphens, and this can cause all kind of additional complications. But still, with the right search tool, you can also identify these patterns pretty easily. And then there are patterns or PII, personal information, which follow certain patterns, but there's an infinite number of textual variations. So it's like a street address. They all have like a number and then the street, and sometimes the street has a name, or it has a name, and then sometimes it's followed by roads or by street or by drive. Or so there are certain patterns, but yeah, you can come up with any name for a street, and this kind of makes it an infinite number. And you need to do some more intelligent, some smarter technology in order to be able to find those words. But you're no longer going to find all the relevant ones by just looking up patterns. You need to start working also with dictionaries, but then the dictionaries will never cover everything you do because dictionaries are finite and the number of possibilities here is infinite. So you need to use some additional complexer technology to identify this. Then we're getting to the more interesting ones. Is like you can have lists of textual patterns for which dictionaries will probably cover 90% of the possibilities, but not everything. And this is with job titles, medical issues, religion, and political. And the more mature the software is that you acquire to do this, the larger these dictionaries will be, and the better they will find these jobs. But there's always a need to review it, the same with the previous two ones. And then the final one, which is the ultimate challenge, is to find textual patterns that can take any form or shape, and that are also very ambiguous in the meaning. For instance, personal names, geographic locations, organizations, product names, and company names. You can have a certain name which can be either of those. So, you can have Mr. Holland. You have Holland, the country. You have a company called Holland selling agricultural devices. There's maybe a product called Holland Cheese. And then there's company names like Holland Incorporated. And so this is kind of complicated, and this is where you really need artificial intelligence and machine learning in order to be able to find all the relevant documents. Having said that, this is exactly what the field of text mining is very capable of doing. Identifying all these types of personal identifiable information, including protected health information, and also data revealing racial, ethnic origins, political opinions, religious, philosophical beliefs, etc. What Ken was talking about, which are also regarded as personal data under the GDPR, and also require very, very explicit prior permission to collect this type of data, and a ordinary checkbox like I agree will not do. You really need to have a signed contract in order to be able to allow this type of data. Now, like I said, this technology is not perfect, so one needs a defensible process. After the auto-redaction process, one needs to review the data. Most economic is to review a random sample. One needs to revise patterns and libraries based on the results. One needs to measure the quality. If a certain quality level is reached, one can stop. And if the certain quality level is not reached, one has to go back and do the whole process again. Now, what we see is typically within 6 or 7 of these cycles, organizations can reach very high quality levels, 98, 99%. And I think it's important to understand that although there's no legislation yet, I do not believe that regulatory agencies can insist on 100% quality. Because even humans, even with best efforts, will probably make a lot of errors. But we've seen in discussions with regulatory agencies, if there had been a lot of effort, if technology had been used, which is absolutely outperforming human performance, and if one reaches 99 or 98% in quality, the authorities agreed with the results. But again, you want to make sure you check this with the responsible agency before you decide that the required quality level was reached.
Yeah, and I have a quick question. There's a provision in the GDPR for implementation of all safeguards called privacy by design and default. Is this sort of tool the sort of thing they're talking about?
Yeah, absolutely. Yeah, you can fit that there, and this will this will help you to reach a certain level of compliance. Yeah, good question.
So
Okay.
Ken and Jan, when you're talking about this process here, usually there's a quality control process at the end of the e-discovery,
Yeah.
a normal e-discovery or e-disclosure project where you quality control for privilege. Are you suggesting that prior to disclosure that this layer be added?
Well,
Yeah,
I don't see. Go ahead, Jan. I'm sorry.
Yeah. Well, I think this process is very similar to the privilege detection process. Now, if you want to use this for privilege detection, well, if you're going to disclose data from Europe to the US, you have to do it anyway. But if you don't have data of European subjects, and if it's within the US, I think you shouldn't worry about it, unless there's US regulations you have to take into consideration.
Oh, very good. Thank you.
You want to add something, Ken?
No, the only thing I was going to say was that, was that technical tools are considered within GDPR as a matter of common sense as well as a matter of law. It's very difficult to meet all these requirements manually. But there are a number of platforms out there with tools that will use machine learning, use forms of AI, forms of text mining to help you get to where you're going to be. And the people who are advising you in your process, your in-house technical resources, your outside consultants, your outside counsel can help you vet these tools to see which ones will really be able to create efficiencies for you, and there are many of them out there. The second thing is there's a lot we don't know yet about the specifics of GDPR because it's so new. The regulators have not, with very few exceptions, issued very prescriptive regs on how this is going to actually be implemented and what metrics to use. But those of us who've been in this space for a long time and have seen the evolution have a pretty good idea of where the regulators are going to go and what they're going to be looking for. You won't be able to find this on the black and white page of the regulation, but if you work with those who have experience in this area, they can advise you.
Yeah. Okay, so where are we going to see this, and where is this going to be an issue? And we've identified 5 use cases where GDPR meets e-discovery. The first is if data is to be transferred outside of the European Union as it relates to any regulatory or e-discovery request or arbitration for the same reason. The second is where parties outside of the European Union need access to virtual data rooms in the European Union for merger and acquisition, real estate, or other types of reviews. It can also be that you're the victim of a cyber incident and you have a data breach or a hacker who've been in your systems, and you need to inform not only the authorities but also the individuals whose personal information has been seen or violated or potentially leaked. It could be that you receive a right to be forgotten request. Individuals from the European Union can ask any company to remove everything that they know about that company, and also they can do that even if they have provided prior consent. They can withdraw that consent, and then you have to remove all that information. Or if you have an old non-compliant, non-GDPR compliant archive, which is regularly subject of information request, or you want to use it for big data analytics, then you may consider to clean it up and migrate it to a GDPR compliant archive, including all the right encryption and cybersecurity for future e-discoveries. Okay, now let's talk about them one by one. So first, what we have is the GDPR and e-discovery. If there is data about certain individuals, and I've seen a couple of questions asking this already, well, what happens if there's data from individuals which accidentally has been collected under e-discovery? Well, although there is no legislation or verdict yet about any of these cases, it is to be expected that all that information has to be either anonymized or pseudonymized before the data is transferred to either a regulatory agency or any civil party outside of the European Union, especially when it's transferred to the US, because in the US it's common practice to make all of the data in e-discoveries and litigation publicly available, and which is a clear violation of the rights of European subjects. So I'm sure that regulatory agencies will definitely prevent that those things are happening, like what happened, for instance, as an example, with the Enron data set, which has been totally made public and is now also used by a lot of companies for demonstration purposes. So this is definitely going to be an issue in e-discovery or regulatory requests. And we have already seen regulatory agencies which have requested data from Europe which had been pseudonymized and before it was disclosed, which apparently has been acceptable for both the European data protection regulatory agencies and the United States regulatory agencies in this particular case.
Yeah, and the only thing to watch out for there is litigation, particularly federal court litigation, where the individual judge makes the rules about what is within the bounds of the federal rules of civil procedure, or if it's a criminal case, the rules of criminal procedure, about what's acceptable and what's not. So it's going to be very important for organizations and their counsel to educate the judges about these new rules.
Yeah, no, absolutely. And then the other problem is that every country has its own regulatory agencies who can also interpret the legislation differently. So despite the fact that we have uniform legislation, there's going to be, in the European side, there's also going to be variations. And yes, there's absolutely a disconnect right now between European laws and federal requirements, which was the case also in the past. But then the fines for the violating European data protection agencies were very low. It was 2,000 euros or something. So everybody decided to pay the fines and not give the data, and then give the data to the US authorities. But now it's that's no longer going to be an issue. So it's going to be a very a complex situation. Okay, in the case of virtual data rooms, there's an additional complication, especially when one has a data room which holds a lot of data on, for instance, mortgages and real estate. Then there's a lot of personal information which has often been collected about these individuals, including religion and job and political preference, without asking for any prior consent. So we've seen cases where this type of information was in a data room, and it was not possible to open the data room for third parties because of the presence of this information. And as a result, the whole deal and transaction could not close. So there was an extreme urgency to remove this data in order to facilitate the transaction. And this is what we see with virtual data rooms and M&A and refinancing, where you better take care of these issues very early in the process. Otherwise, it's going to harm your whole process. GDPR has a lot of text, a lot of regulations, a lot of rules about cybersecurity. Like Ken said, within 72 hours, a regulatory agency in Europe has to be informed about the breach. But you also have to inform all of the suspects whose personal information has been leaked. And you have to ask yourself, what is personal information? Now, somebody's email address, you can say, well, that's not really your personal information, because it's all over the internet probably, and it's got something you need in order to send this information up and down. But it could be that within that email or within that file share, there may be a personal health information from you, or there may be a mortgage or financial information. Now, as soon as this type of information is present, you want to inform the individual. You have to inform the individual that her or his information has been leaked. And yeah, what we've been doing already is projects where we, after a cyber breach, we collected all the data, we analyzed it, we found which personal information was contained, and then who were the particular individuals whose information was leaked, and then we used this information to generate a report which facilitated the process of identifying those individuals. There's something really, new in the GDPR, which I already mentioned. It's the right to be forgotten. And this already exists in certain European countries, but now it has been made a general part of the GDPR for all over Europe, which means that you have to search for their names, not only in databases, which is often pretty easy, but also in non-structured data, in email. And yeah, in theory, again, there's no legislation here, but in theory, if you have e-discovery data containing the names of certain individuals from Europe, that European individual can ask you to remove their names, because especially if their name is part of a data collection where they have no blame, they have nothing to do with e-discovery, and there's no reason why their data should be there. Now, in that case, you need very good search technology to find those types of information where the data is located and remove it. And then finally, your legacy archives. So how do you deal with your legacy archives? And this is what we discussed in the beginning, where if you do have archives which contain a lot of personal information for which you probably have not asked prior consent, or you do not really need them for your business, but you collected them as collateral damage, so to say, of other activities, then you may want to, and if you still have to keep these archives for compliance reasons for your U.S. regulatory agencies, or then you may consider cleaning up those archives and then storing them in a secure environment which stores this type of information encrypted, or remove all the personal information and use different types of all the different authentication and other security requirements that are required under the GDPR. Just to give you an overview.
Jan,
Yep.
Jan, what about productions that have already been made? Do you need to do anything about those productions after the GDPR comes into effect in May, or is the fact that they're out there already?
I don't know. It's a very good question. It's a very good question. We will see. Yeah. I don't know. One would say one has to, right? But then that's going to be a big problem. Yeah. Do you have any idea about that, Ken?
It's part of the general concept that there is still a lot that needs to shake out here. The people who drafted the GDPR had a particular view. They were not within the business organizations or the industries of those who are going to be affected by it for the most part. So as we saw with the directives, where we had many guidance documents from the Article 29 Working Party on data protection, we're going to have the same thing here. And we're going to have variations by the individual countries' data protection authorities.
Yeah. Well, and you can also, I think a lot of this is not clear yet, Mary, but one of the things that's also not clear is like the workflow. What happens, let's go back to you're discussing an interesting point at the end of a discovery, but what do you need to do in the beginning of the discovery? You're going to collect data. Now, if that data is collected by a U.S. e-discovery vendor, and that U.S. e-discovery vendor takes the data to the U.S., that's already a violation of the GDPR. So maybe this means this can only be done by European vendors, unless there is a very clear privacy shield in place, but it's probably safer to have it done by European vendors. Then remove whatever is not relevant, redact it, and only then disclose it to U.S. parties. But again, it's not really clear right now what the authorities are, how they're going to do these type of things. So maybe it's better, to be safe than sorry and don't take too much risk here.
Well, and in that regard, because litigation is a bit of a swashbuckling affair in the U.S., I generally advise clients, particularly when you're dealing with unsettled landscapes like this, to ask 5 questions before you and your counsel go after any data. One is, what do you want? Second is, why do you want it? You don't necessarily need to get data just because you can. Third is, where is it? Which then goes into whose laws are affected. Fourth is, how will you get it here? And the last is it useful? Is it admissible once you have it? I can't tell you the number of cases I've been involved with where people have requested everything under the sun. Beyond the fact that that's a violation, it busts the litigation budget. It makes the judge angry or the regulator angry when people have discovery disputes. And it does absolutely nothing but delay the resolution of the matter.
Yeah, no, absolutely. Yeah. So let's see, maybe this brings a little bit more sense into e-discovery.
Well, I think it will, but you're still going to have the issue of getting U.S. regulators and judges to pay attention to it, and that's an education process.
Yeah. Now let's take a look at the ROI of the blacklining process, comparing manual to automatic blacklining. Now we've had these questions. We've used this technology for a long time already at all the war crimes tribunals. So we have been doing a lot of ROI calculations where we were also able to compare our technology with manual labor. So what we've seen is in a recent case where the digital blacklining manually took 1,800 hours, 4 eyes were needed, long turnaround, multiple reviewers for a longer period. And then the automatic blacklining with 100% check, we checked everything, took half of that, a little bit less than half of it. And automatic blacklining with random checks, only 3%, which resulted in almost exactly the same results, only took 120 hours. So it's by far 10 to 15 times faster. And that's what we see in general by using these type of machine learning and AI technique. It's better, faster, more cost effective and smarter. And that's the way forward. Okay, now I want to move on because I want to be careful with the time. If you want to try this yourself, you can sign up for a demo at our website. Just go to www.xylab.com and sign up for the free trial. And then we give you access and you can see how this is done on the annual data set. We also have a community where you can sign up for, and you can watch videos, training videos that give you an idea of the whole process. And we have a very rich content library with much more reading and ebooks on all of these topics, or on GDPR, on redaction, but also on technology assisted review and how to handle regulatory requests in this more and more demanding world. Okay, I think we have a whole lot of questions here, right, Mary?
We do, but let me ask this one. So we know about the EU citizens. And that we need to be careful there. But if a U.S. citizen worked for a U.S. company and the U.S. company was sold to an EU company and they took all the data to the EU, so will the U.S. citizens' data be covered by the GDPR? I think that's a Ken question.
Yeah, thanks, Mary. The GDPR doesn't talk in terms of citizenship. It talks about EU data subjects. So if the U.S. citizens' data is in the data repository in the EU, again, there's very little guidance documents on this, but it seems to me just reading it and knowing what I know from the directives, I would say it's covered.
Okay. And then what is the play when you do need to show the information like sender, recipient, and things like that? Is pseudonymization accepted by the U.S. courts?
It hasn't been yet, to my knowledge, except in very limited circumstances where the courts have been advised of particular sensitivity of the individuals in the matter. You often see this in criminal cases. I think if pseudonymization is going to be something that a U.S. court in a civil matter is going to agree with, the court's going to have a way to be able to re-identify the data in some fashion, if for no other reason than to make it relevant. Now, not all identifiers are relevant in all data. It's going to be dependent on the particular kind of case, and whether tracing it to the individual is what makes it relevant in order to be able to admit it into evidence, because relevance is your first inquiry in court.
Excellent.
Yeah,
and then
I fully agree with it. But I've seen regulatory agencies already accepting this, and I've been involved in e-discovery where this was actually, pseudonymization was actually agreed between the parties because otherwise the data from the European Union would not have been disclosed. So in order to get the data, it was insisted by the disclosing party that it had to be pseudonymized, and then the requesting party accepted that.
Yeah, I've seen it as well in some of the larger class actions where the custodians were numbered, and that was the way of getting around having people's names be out there. So I want to be respectful of people's time. So the last question I'll ask is, given the uncertainty in this area for litigation, what is the best way to transfer the data to the U.S. if it's determined that the data is needed or required for a litigation?
Well, I think the first question you have to ask is, as I said, why do you need it? What do you want to accomplish with the data? And that will tell you what safeguards are appropriate for that particular data. If you're looking, for example, in a product liability action where you want to know what the engineers said to the senior executives, and the names of the senior executives are real important because you can attribute knowledge of the corporation and actions to those senior executives who have decision-making power, it will be a real uphill battle to get a court to accept the fact that you don't need the names. But not every case is like that, to the point both you and Jan were making earlier. It's really a fact-dependent inquiry, and there's no one-size-fits-all here. You have to ask the questions about why you need the information and what your end goal is for using it to determine how you're going to get it here, and critically, plan for that, and plan to be able to advise your adversary and the court in the Rule 26F and the Rule 16 conferences about these issues, but make sure you've got your arguments thought out in advance and have a contingency plan as well.
And then from a practical standpoint, Ken, you had mentioned earlier encrypting data. So encrypting at rest if you're putting it on a drive, encrypting it in motion if you're sending it over the wires, that would be kind of a minimum.
That's a minimum. That's different, and that's a requirement that is separate and apart from the ones that Jan's been talking about. So yeah, absolutely, you should do that. And also, when you get it, store it in encrypted fashion. Don't keep it on an unencrypted USB drive, which can get lost very easily.
Yeah, but that's like Ken said, that's for storage. Even if it's within the European Union, you have to store it encrypted with two-factor authentication and everything and all the other security measures. But yeah, even if it is encrypted, you cannot disclose it. You have to remove personal information before you disclose it to any party outside of the European Union.
Excellent. Well, I have a feeling that this is going to be a topic that we're going to revisit a couple months after the GDPR goes into effect and we start seeing some of the first enforcement actions. I hope you two are up for a subsequent discussion.
Sure.
And we do have a couple of questions that were not answered, and we'll make sure that we reach out to you and get your questions answered. I want to thank you, Ken, and you, Jan, and Zylab and Anna Lore for hosting this lovely webinar. And I want to thank everybody for on the ASEDS webinar channel for stopping in, for listening, for participating, and for your good thoughts on this cutting-edge issue. So thanks very much. We'll see you in the next time on the ASEDS webinar channel.
Thank you, Mary. Thank you, Jan.